Welcome to Discovering the Law. My name is Lucy Rivera and I am the host of this program. If you would like to view this episode, you can please visit us at www.discoveringthelaw.com, or you can contact me at lucinda.rivera@discoveringthelaw.com. Today, we have a very interesting program that deals with debt collection, and we have invited attorney Thomas Beauvais.
Thank you.
Attorney Beauvais, thank you so much for being here.
Thank you for having me.
Please talk to us about consumer law. What is consumer law?
So consumer law is basically, in any business transaction, or anytime you buy something, there are two sides of it. There's the business side, the person selling something, and the person who's buying something.
Yes.
And so consumer law involves the person buying something side of things. And so it's all of the laws that protect those people.
Okay, and how easy is it to get into debt for credit cards or other debts?
Yeah, it's actually incredibly easy to get into debt these days. Credit card companies basically gamble on individuals like a person would at a casino. They really look towards locking people in to a minimum payment contract for the rest of their lives. That way there's a constant revenue stream for them.
Well, talk to us about the interest rate issues that triggers and
Yeah, so one of the issues that certainly people face, and one of the ways that banks are able to lock in an individual is through interest rates. The National Banking Act allows a bank that operates on a national level to charge whatever interest rate their home state allows them to charge. Now, because of that, you have a situation where someone in Massachusetts is being charged an interest rate that could possibly be illegal here in this state.
so just to expand on that, the National Banking Act regulates the interest rates.
So the National Banking Act regulates banks as a whole, but one aspect of that law is that it set out that banks can charge whatever interest rate their home state allows. So a lot of banks, once that law was put into effect, moved to South Dakota, moved to Delaware, moved to North Carolina, with the purpose of taking advantage of the interest rate laws in those states. So a state like South Dakota doesn't have what's called a usury statute.
So let's take it step by step and break it down a little bit. In Massachusetts, what is that interest rate for debt collection, for credit card
Sure. So
interests?
in Massachusetts, it's considered to be illegal to charge any interest rate above 20% interest per year.
20%. However, you're talking about other states now.
Right, exactly. So there are states like South Dakota that doesn't have that kind of limitation. So you can have a bank charge upwards of 30% interest on a credit card for a Massachusetts resident, and even though the law here says that that's illegal, that you cannot charge more than 20%, because of the way the National Banking Act set up the system, they are not bound and they can circumvent those usury statutes.
Now, the usury statutes, you refer to the ones who set the interest rates in Massachusetts, for instance, which is 20%. Explain to us, why is that conflict? For example, like the states you mentioned, South Dakota and Delaware. Why is that conflict, and why is it that those states with higher interest rates are allowed to collect that high interest rate here in Massachusetts?
Well, so any state is allowed to set up any laws that they want, and typically, I mean, the basis of any law is what the society considers to be good and reasonable. So here in Massachusetts, we say we don't think that anyone should be allowed to charge more than 20% interest. But in South Dakota, in order to get the business of the banks, they'll say you can charge up to 30% interest.
Okay.
And because of the National Banking Act saying the state usury laws don't apply except for your home state, a bank that is based in South Dakota can charge the South Dakota interest rate anywhere in the country.
Because that's their home state.
Right, exactly.
And that means that those banks' headquarters are in that state.
Right, exactly.
Very interesting. So this gives rise to a lot of abuse.
Certainly, it absolutely can, because you end up with a situation where people are locked into continuing amounts of debt. I mean, if someone accrues $1,000 in debt on a credit card, every year on a 30% interest rate, they're going to pay $300 in interest. And typically, when a minimum payment is only going to be $30, you're never actually going to get out of that debt because most people can't afford to pay more than the minimum. And ultimately, you end up in a situation where someone ends up becoming essentially a lifelong customer of a credit card bank simply because they made possibly even just one purchase years ago.
Why is it so easy to get in this debt, and why is it such an industry?
So credit card debt is incredibly easy to obtain. As anyone knows, you end up with solicitations in the mail. You end up with these pre-approved offers in the mail. You can go on the internet and very easily obtain a credit card. You can even call over the phone and give your information over the phone, and that can get you a credit card. So it's incredibly easy to get the debt. And certainly some people are in such financial dire straits that they need to seek out some way of being able to pay for something now and then pay it off later. That it's created a system where desperate people go to this, and unfortunately it ends up hurting them in the long run.
For example, people that unfortunately might have lost their job in the economy, they need to pay their rent. They put their rent on the credit card.
Yeah, absolutely. Somebody paying for their car payment or their rent or even their mortgage possibly using their credit cards, because if you don't have any money, that's money.
Yes.
And if you're desperate, if it's the difference between eating or not eating, you're going to make that decision very quickly.
So that sounds very, very difficult and dangerous. How are some of the proper ways to collect, or what are the ways that these debt collectors collect the debt?
Sure. So typically banks won't collect their own debts. Once you stop making payments on your credit card, it goes into something called default. Okay. And then the bank will do something called charging off. And they'll actually sell that debt to another company. So this company had nothing to do with creating the credit card or maintaining the credit card, but their purpose is to buy the debt for cents on the dollar with the intention of collecting the full amount of the debt and making a profit.
Okay. And how do you expect to hear from these people collecting your debt?
So typically the way that somebody will get in contact with an individual consumer is you'll have these debt buying companies or a debt collection company. They will either call a consumer or they'll send them a letter in the mail.
Okay. Now, who regulates how this debt can be collected? It just sounds like it could give rise to abuse.
Sure. So there's a law in effect called the Fair Debt Collection Practices Act. And basically that's a federal law that sets up prohibitions on what debt collectors can and can't do in the process of collecting a debt.
Okay. Describe to us that law. Specifically, what is the process of fairly or legally collecting that debt?
So certainly if somebody owes a debt, a company has every right to try to collect that debt.
Yes.
But there are some limitations. So you're allowed to send people letters, you're allowed to make phone calls, you're allowed to try to get in contact with them. But certainly there are limitations on that. But as far as going about it the right way, you can make reasonable number of phone calls, you can make send reasonable number of letters, and of course you could always file a lawsuit.
File a lawsuit, okay. I wanted to follow up on that question. I wanted to ask you what are the incorrect ways of doing that, but go ahead, let us know.
Yeah, so some of the major violations that you'll find in the debt collection law is calling people too much. You can't harass somebody and call them too often. You certainly can't call someone using what's called an auto dialer. You can't send letters to someone's work, or you can't send letters to someone's family. Essentially, you can't tell someone who doesn't owe the debt that you're collecting a debt against another person. The term for it is third party. You can't tell a third party about the debt. And certainly that is something that we see a lot, and it is one of the more prevalent violations of the Fair Debt Collection Practices Act.
Before we go into the violations, it just sounds like this has become an industry in that when people get into debt, credit card or mortgage or any, Did you have a sense as to what this industry is? Can you describe to us what
Sure.
they do and what is it?
Absolutely. It's a nationwide industry. Some of these companies are enormous, not in the sense that they have large staffs, but that they have huge portfolios of debt. We're talking about companies that will buy these debts in portfolios of thousands of debt at a time, thousands of debts, individual credit card accounts at a time. So they'll spend, a few $1,000,000 to buy tens of millions of dollars worth of credit card accounts, and then try to collect on those credit card accounts afterwards. So this is a nationwide industry that is certainly multi-million and possibly even multi-billion-dollar industry.
And what is the law that regulates how this industry can collect this debt?
So that's the Fair Debt Collection Practices Act. There are some state laws, but essentially the state laws mirror the Fair Debt Collection Practices Act. So the guidance is really at that federal law.
Very good. And in Massachusetts, specifically, talk to us about the Massachusetts debt practice.
Sure. So recently, the Massachusetts Attorney General changed their regulations when it came to debt collection practices to essentially cast a wider net. So the Fair Debt Collection Practices Act says that anyone who's collecting a debt for someone else, so a debt buyer or a debt collector, is regulated by that law. In Massachusetts, we cast a little bit of wider net in the sense that we don't just limit it to people who buy debts or collect for someone else. We'll also apply the same violations that you'll find in the federal law. We'll apply those to people who actually create the debt in the first place, like the banks.
Okay. Now, what happens if these debt collection agencies or parties violate the fair ways of collecting debt? And before we go there, what are the fair ways? Can you just tell us, besides calling, and what would be a legal way to collect this debt?
So a legal way to collect the debt would be to send what's called a Dunning letter. And that's basically just a letter that says you owe X number of dollars to this company, likely a credit card bank, and we're offering to accept X number of dollars in order to clear up that account. That would be a legal way of collecting a debt. Or calling someone and saying, we're a debt collector, and we want to talk to you about a debt that we believe that you owe.
Very good. So in today's program, we are talking about debt and how you can win a lawsuit when it comes to a lawsuit to collect a debt, and how you can win and dramatically reduce your debt. Our guest today is going to teach us this. It's attorney Thomas Beauvais, and we will continue hearing from him. Please tell us, what are the violations and what is an erroneous or an illegal way of collecting debt, and what are the penalties?
Sure. So some illegal ways of collecting debt, like I mentioned, are harassment, but certainly threatening somebody, threatening harm, or threatening to take action that you're not legally allowed to take. There was a recent problem with a company that was claiming to be working on behalf of the district attorney's office in order to try to collect debts, and that's certainly not allowed. And the penalty for those kind of violations are that the consumer can actually sue the debt collector and collect up to $1,000, regardless of whether or not they lost any money as a result of the illegal practices.
Now, how would somebody think that the way their debt is being collected is illegal?
So if you have a bad feeling about the way that they're talking to you, that's certainly a good way of doing it. Most consumer advocates will talk to people for free. Because it is certainly an issue that all consumer advocates deal with, and also not on top of the $1,000 that you're allowed to sue for, you also are allowed to recover your attorney's fees. So whoever represents you in that lawsuit, you don't have to pay them, because if you win that lawsuit, the debt collector will have to pay the attorney for suing them.
And award you with $1,000 for your
trouble.
Trouble.
Yeah.
Oh, that's very interesting. So what should people do when they, speaking of attorneys, when they get a call requesting that you pay your debt, or a letter in the mail asking for that debt? What should they do?
So when you first get a contact from a debt collector, the very first thing you should do is send what's called a validation letter. And it's a very simple letter. You send it to the company that just contacted you, and you say, I would like you to validate this debt. And
Okay, so let's break that down for
Sure.
our audience. When they receive this letter, you need to answer it, and that's called a validation letter.
right.
Okay.
And a validation letter basically puts the company on notice that you want proof that the debt is valid, that you actually owe it, and that the company that's collecting it is actually entitled to collect it. Because as I mentioned, these companies buy the debts, but because they buy them in such large amounts, there's mistakes along the way. And so they could get your information even though you're not actually one of the debts that they purchased.
Okay, so answer the letter.
Yes.
um, and challenge it, or
So,
will they-
you know, one of the things that can end up happening is even though you try to validate the letter, and that's going to put the debt collector on notice to give you information, they may still sue. They may still file a lawsuit against you. And in that process, what you want to do is you want to answer the lawsuit.
But before you get into the lawsuit, what if,
Sure.
what if it's just phone calls? You know, everybody, like, I'm your credit card and you owe us this. What should people do then?
Yeah, well, one of the things the law says is that when you get your first phone call, within 5 days, that same debt collector has to send you a letter.
Oh, okay.
And that letter says that you have the right to validate the debt.
Okay, very good. Okay, now speaking of the lawsuits, people who did not answer, did not do any of this, then you're saying that the company sues them.
It's one of the easiest ways to collect debt in this country because a credit card is still technically a contract, and so you can sue to collect the money on that contract.
And you receive a complaint in the mail.
Yes, so the sheriff is required to serve any lawsuit in Massachusetts. Typically, the way they'll do that is to send it to you in the mail.
Okay, so teach us how to win a debt collection lawsuit in Massachusetts. What does that mean to win? Because obviously it's an obligation. You
Sure.
accrued a debt, it's your debt, you need to pay it. But what do you mean when you say let's win a lawsuit in
Yeah,
Massachusetts?
so winning a debt collection lawsuit is really making the process fair. So the very first thing you should absolutely do is answer the complaint. And the complaint is the document that you'll get that says this is what you owe. What you want to do is send the document to the court and to the attorney that filed the lawsuit that says I don't owe. And that document doesn't have to be any specialized form. It can be, and you may want to hire an attorney to help you. But nevertheless, all you really need to do for most of these lawsuits is just send a document to the court and to the other attorney that says, I don't believe I owe this money.
Send them a note, tell them denying it.
Right.
Okay, and now is it possible to dramatically reduce, to continue?
Oh
down
yeah,
this process?
absolutely.
Oh.
So one of the key issues that anyone will face in a debt collection lawsuit is, as I mentioned, the debt is usually purchased by another company, that debt buyer. And a debt buyer will have to prove in a court of law before they're allowed to collect the money that they actually properly purchased the debt. And there are very specific rules on how that happens. And they'll have to present documentation that they purchased it.
And tell us what they need to show.
So they'll need to show a document that says that they purchased accounts from the bank, and then they'll also have to show in that same document that your account is the one that is one of the debts that they purchased.
Okay. And
Another way of certainly challenging a debt collection lawsuit is that you'll want to challenge the amount that they're claiming. You're allowed to ask them for all the documentation they have to prove their case. And the way that you can do that is what's called discovery. And when they send you the documentation, you may be able to find that they're asking for more money than they can prove they're entitled to. Another way to deal with it is the fact that they may not even have the contract itself. And because they're suing on a contract, the law says you have to produce that contract. And if you don't, you're not entitled to things like interest or late fees or collection fees. And so that might dramatically decrease the amount of money you owe because you may have made a $1,000 purchase, but they're suing you for $8,000 simply because it was interest and fees that accrued over years.
Now, what are the resources available for people who need help with their debt? Where should they go, and what qualifies for them to get some resources?
Sure, absolutely. So there's an organization called the Volunteer Lawyers Project that at the courthouse on New Chardon Street, the Boston Municipal Courthouse, every Wednesday they have a clinic where they talk to debtors about their defenses in a debt collection lawsuit. You don't have to have a case on for that day. You don't have to have a case right away, but you should go there anyway because they have free attorneys who will give you advice and may even represent you for free if you qualify.
And now, what are some defenses that they can claim?
Sure. So one of the key defenses that anyone should look into is if the person suing is a debt buyer, the defense is called lack of assignment, so that the debt was not transferred properly to the company that's suing. Another defense is what's called the statute of limitations defense. Basically, any contract, you have to sue within 6 years of the breach of that contract. So if they wait too long, you're no longer legally obligated to pay that debt under the law. And so that's another defense that's very common. And certainly challenging the amount of the debt is a defense that everyone should try to take advantage of.
And can you think of specific examples where this would apply?
Sure. So dealing with a debt buyer situation, you'll want to say you don't have assignment. You can't prove that you own this debt. And they'll produce their documentation, and a lot of times what they'll produce is a document that says, we bought X number of dollars worth of debt from Capital One or from Citibank or whatever, any of the credit card banks. And they won't have any document that says they bought your account. And when you get that, you can tell the judge or tell a jury, however you decide you want to present your case, that if they cannot show that your account was one of them, then you're not legally responsible for paying. Because someone else could come in afterwards and say, we actually bought this debt, and here's our proof. We bought X number of dollars worth of debt from the bank, and here's the proof that it's your account. And now you're paying two companies for one debt, and that's something that we don't allow in this state.
Very good. And who is the body overseeing that these abuses don't happen, or like the attorney generals? But what is the?
So the attorney general certainly has the authority to go after any of these companies that abuse the system. But it's really up to every individual to keep track of their own situation. When they get sued, it's their responsibility to show up. 90% of all cases that are brought on debt collection in the court systems end up getting what's called default, which means you lose because you didn't even show up. And it's a shame because so many of those cases could be won or dramatically reduced.
And tell us about that. So in the game, the most important thing is showing up, as you say.
Yes.
But what happens then? You showed up, but you owed your debt. It depends on specific examples.
Well, absolutely. Everybody's situation is different.
Right.
Every lawsuit is different. But a lot of times, there's something defective in that lawsuit. Either the amount, the person suing, or when they bring it. And so it's very important to challenge it. They have, the person bringing the lawsuit has the burden of showing that they are owed the money. The person defending the lawsuit doesn't have to say, I don't owe it, but you can challenge it and make them prove it. And if they can't prove it, then you won't be found legally responsible for paying.
And what happens when you don't show up and automatically there is a default because you didn't show up? What happens then to your case and to you?
So if you're defaulted, one of the things that will happen is that the debt buyer will be able to go to the court and ask that they'll be allowed to garnish your wages, that they could put a lien on your house, they could seize your car. The collection process, and the reason why they like going to the courts, is because they're given these wide varieties of ways of collecting the debt that can be very intrusive on somebody's life, especially when it comes to wage garnishment or putting a lien on your house. You can't refinance your home if there's a lien on it.
Oh, so you need to show up. Otherwise, you're giving free range to these agencies to just have legal ways to garnish your wages or put liens, which they didn't have otherwise before.
Right, exactly. You're not allowed to do those things unless you get a judgment first.
Wonderful. Well, this has been a really interesting program. Thank you very much for teaching us about the status of debt in Massachusetts and the laws governing debt collection.
Thank you.
Thank you to all of you for watching us. And again, my name is Lucy Rivera. I'm the host of this program, and this is Discovering the Law. We thank Attorney Thomas Beauvais for being here with us. And please let us know your questions at www.discoveringthelaw.com. Thank you for watching.